Both the appeal dismissed.
Number 39. 619 of 2020.
Petition allowed.
Much obliged.
Number 40. WBC 8147 of 2022.
Petition allowed.
Deeply obliged. This will I listing the interlocutory application for correction of.
Take a date for man.
May previous lawsuit. I am not maybe audible lawsuit. Victimization for listing even RSA lawsuit.
Pardon?
RSA after verification any date lawsuit.
Which one?
After verification any date lawsuit.
Which matter?
RSA.
Mention.
Mention for listing.
Take a date from him.
Profit, the first. Action for.
Not today.
This is for the correction of the order, Malad.
Not today.
On 19 Malad immediately.
May I plead your lordship? My lord, it's an NSC appeal, my lord, may be listed on 21st January.
Take a date from him.
May it please your lordship, lordship, I may be, item number 20, I beg to mention item 25, lordship. We may be allowed, and for the respondent number 1 and 2, we may be allowed to withdraw our ukalatnama, lordship, as we can.
Item number?
25, lordship. We may be allowed to withdraw our ukalatnama as because we could not contact him for long time.
Item number 25.
Yes, lordship.
IN number 962.
Yes, lordship.
Miss, your name please?
M. Das, lordship.
But the other party is absent now. We'll call the matter. Yes,
May please, your lordship. I am praying for listing of a CRP Malad. New.
take a date from him.
May please, your lordship. I'm here to pray for the adjournment in item number 36
Item 36.
with consent of the both side, with the respondent side.
Mr.
Yes, Sharma.
Learned counsel for the appellant.
Appellant.
You
Yes.
inform the other side?
Yes, sir.
With consent from the other side, press for listing the matter after vacation.
Yes.
Here allowed.
May please, your lordship. With the consent of the other side, I beg to mention item number 32 of today's list.
1-3.
Lordship, kindly pass over the matter for the day.
1-3. 1-3.
32.
Mr. N.M. Dotto, learned counsel for the applicant. With consent from the other side, press for adjournment of the matter for the day. Fair allowed.
Obliged.
The matter stands adjourned for the day.
Items for motion, item numbers 1 and 2, pardon me.
Order dated 15/12.
Can we take it immediately after the vacation, your lordship? Here, we are supposed to file the affidavit, your lordship. In fact, the affidavit is ready, your lordship. However, certain documents we have asked from the department, your lordship, that have not been provided to us, your lordship. So immediately after the vacation, your lordship, by the time we file it.
Lordships, on 18 December, lordship, Mr. Standing Counsel Kaushik submitted that he would apply, he would file the affidavit by 5th of January, lordship. And that is why lordship posted the matter of 9th January. So that if any response from our side also maybe filed addition.
Okay. Heard Mr. M.A. Mondal, learned counsel for the petitioner. And Mr. Islam for the petitioner in WPC number 6997 of 2025. Ms. Musahari, learned standing counsel for the respondent in secondary education or elementary?
Secondary,
Secondary division.
secondary.
Education Department submits that the affidavit is ready. But due to non-availability of some of the relevant documents, the same could not be filed and seek price for listing the matter immediately after reopening of the vacation. Pair allowed, recess shall list the matter immediately after reopening of the vacation.
Lordship,
For admission.
Lordship, in my case, Lordship, on 18/12, Lordship, order may kindly be perused, Lordship. 18/12, Lordship, it is stated that there is an interim order that may continue, Lordship. Actually, there is no interim order. So today, Lordship may kindly consider my interim order, Lordship.
Let the affidavit be filed. Interim order will be considered later. Mr. Mondal, in your case, there is interim order.
There is no interim order.
No interim order.
In my case, Lordship.
Since my lord, motion matter is taken up for disposal, my lord. So considering that, my lord, no interim order was granted.
Okay, we will rectify the defect.
Lordship, a date may kindly
Date may be
fixed,
fixed, madam.
earlier.
Take a date from him.
Doctor, last time interim was not given, Your Lordship, so this time
Pardon?
interim was not given on the last.
Interim was not given, but some mistake has been committed by the.
Lordship, that I pointed out wrong.
Lordship.
Lordship, a line may kindly be added, like if no
Sir,
affidavit
Islam?
is filed, Lordship, into my interim, Lordship, on the next day.
Lordship.
Items for admission. Item numbers 3 and 4.
So, well, interim order will be considered on next step. Media के तो कोई नहीं मारे बातें नहीं होता है
Lordship heard this matter earlier. It relates to the selection to the post of principal National HS School. The respondent number 5, Mr. Nandi, was required to obtain instructions as to whether my prayer with regard to finalization of the selection process, that he has got any objection or not. Yeah. Lordship, and I am going to retire by November of this year, Lordship.
When?
So.
When you are going to retire?
No, November, Lordship.
Now we are in January.
Yes, Lordship.
Mr. Nandi is absent today.
Yeah, he is not present, Lordship.
To record to cycles and kill is. But can we hear the matter in absence of Mr. Nandi?
Lordship, otherwise I am just praying for finalization of the process which was undertaken earlier, Lordship. That much only I am praying.
Yes.
That instruction or presence of respondent has to be taken care of.
Respondent number.
It was
So
heard.
as court has passed an order to get some instruction, whether he has any objection or not. If that object, he has no objection, then matter
Can be disposed of.
for the person.
Okay, let us wait for some time. Let Mr. Nandi come.
Reopening, Lordship.
Reopening.
Reopening, Lordship.
See, today only, otherwise it is getting delayed, Lordship.
Getting delayed, all right, but in absence of the council.
Lordship. I understand.
Okay, so let us wait for some time. In the meantime, the court master will contact the council. Bobby? Thank-
Let's go.
Item number 5 to 9. This matter, Lordship,
On behalf of the department, Advocate General, Lordship, but this is out of session today. So let's kindly change the matter immediately after.
Lordship, if I may, Lordship, the respondent's part is over, Lordship. Only the petitioner's reply is left, Lordship. Lordship can hear the matter today and reserve it, Lordship.
Respondent part is there. Respondent part is there. Argument.
The additional affidavit, Lordship, we have replied to the same, Lordship.
Lordship will fix it on either 21 or 22. It might.
Lordship, it is here us today, Your Lordship. And Lordship can.
Lordship, the date may be fixed for them also, my lord, because my lord, almost all the petitioners, they are exceeding their upper age limit also, my lord, in some cases, my lord. And apart from this, my lord, the huge number, 11,000 something posts are.
And appointments are being issued, Lordship, new advertisement being issued time
My
after
lord.
time after time, Lordship.
Lordship will fix it on 21 or 22.
These are all illegal appointees, Your Lordship, per se. All illegal appointees, Lordship, but they don't have the necessary qualification at the time of
My
appointment.
And when they are trying to now regularize this.
All illegal appointees.
So what is the ground for adjournment?
It is, we are out of session today. That's the technical option.
AGA.
Yes.
It is out of session. That's
Oh.
21.
AG.
AG, my lord, that's the.
AG will appear.
He had argued. Then thereafter, Lordship was directed to file an incentive. That was fine. Thereafter. It was kicked out today. Then always, we fix it on 21st or 22nd, my lord, we will go.
But on 21st or 22nd, this court will not be sitting here. I will bench it outside.
That's it. Lordship, fix
Lordship,
it.
let us make a submissions today, Your Lordship. They may reply later, Your Lordship. Let us make a submissions today, Your Lordship.
Now, if the AG is absent today, then
That's the difficult one. Lordship will fix it.
Lordship, if I am to understand, Lordship, the respondents have completed their part, Your Lordship.
Well, Lordship,
There's only petitions have to give their reply, Your Lordship.
that is only the additional evidence.
That is only in the additional affidavit, Lordship. We reply to the same, Your Lordship. There's nothing much, just 2-page additional affidavit, Your Lordship. Lordship, please to go to the same. 2-page, reply to the same, Your Lordship.
no, let the AG appear.
Lordship will fix any day after then, Lordship not there on 21st, okay, second, my lord, first week of February.
Heard, Mr.
Lordship, J. Laskar, N. Gautam, M. Das, Your Lordship. Jacqueline Losco.
J. Lashkar in item number 5, my lord.
J. Law score in WPC number
W 3879. My lord, one thing, my lord,
3879.
my lord, in 3879.
My lord. Advertisement issue.
No, my lord, all difficulties, they are going ahead with their fresh advertisements. My lord, if there is a conflict of interest, I think court work is more important than other works. My humble submission is, my lord, 11,000 and odd people were appointed absolutely arbitrarily. And my lord, to take steps, see, it's a matter of 2019. And they are relying on a circular of central government which speaks of, my lord, in service, whereas they have made appointment of new recruits. They are in their affidavit, they are relying on a circular of Government of India which speaks of in-service recruits, those who couldn't have this qualification as per the NCT Act.
2024 regularizing illegal.
Let it be taken up on 19, my lord.
19, I'm not sitting
Oh,
here.
I'm sorry.
That begins, I already proposed 21, 22.
No, my lord, this is not the way you deal with the rights of the citizens. Holding brief for state, it has got an enormous responsibility. Anyway, my lord.
Learned counsel for the petitioner, and also heard Mr. P.N. Sharma for Elementary Education Department, and Mr. Bora for SSA. Mr. Sharma and Mr. Bora submits that the learned AG will argue the matter and he is absent today and press for listing the matter immediately after reopening of the vacation. Accordingly, taking note of the submission of learned counsel for both the parties, the matter stands adjourned to be listed on 4th of February. Five.
My reply may be bring on record, item number 5.
Mr. Laskar, learned counsel for the petitioner submits that he has filed his reply to the additional affidavit filed by the respondent authorities. And the same has not been placed on record, and accordingly it is provided that the SSL place the same on the record.
Habla.
Their murder DNA প্ৰথম list হৈছে আগৰ পৰা চাই মাৰি দিছা
Your Lordship, order by order dated 2/12/2025, my lord, your Lordship. Two 2000. May I read, my lord? During the course of deliberation, attention of this course was drawn to page 74, page 74, wherein it is stated that gazette teacher with pay band 2 is entitled to scale of pay so and so, and this gazette scale had been published in Assam Gazette extended March 2017, and this page 74 appears to be contradictory to the stand taken by the respondent 2 in the affidavit in opposition dated 12/11/2000, and especially paragraph number 6 and 7. In that view of the matter, Mr. Sharma, learned standing counsel for the respondents in secondary education department, is directed to produce the relevant document in support of the contention being made in paragraph 6 and 7 of the next date, my lord. My lord, during this time, my lord, these days, my lord, I received, my lord, one, my lord, notification.
Pardon?
I'm not received it now. During this, my lord, time, I've got, my lord, one notification, my lord, which are not record on, my lord, because of that. My lord, petitioner was completed diploma training 2012, and he has got the graduate scale of pay, my lord, 2012. And this is the notification, the revised by the finance department notification 9/2011, my lord. This is they are directed to, there is a notification on 19/2011, my lord. Those who are completed, my lord, training, basic completed in training, my lord, they have received the graduate scale of pay as per this, my lord, notification. If I am going to read, my lord, grant of pay 2,700 to all trained and graduate assistant teacher, ME, LP, senior basic, junior basic, pre-primary school. With reference to the subject cited above, I am directed to say that all the trained and graduate assistant teacher, ME, MBA, LP, senior basic, junior basic, have not reportedly got grade pay 2007 as per the guideline of the finance department. You are therefore requested kindly to ensure payment revised pay 2007 to all the trained and graduate assistant teacher, MS so and so, as was granted by the Assam Service Revision of 2000 and revised by the finance department by notification dated number so and so dated 19/2011, my lord. 19/2011, there is a finance department notification to give the all, my lord, graduate scale of pay. On the basis of that way, my lord, petitioner received, my lord, graduate scale of pay. And that is the, my lord, I have received this, my lord. If honorable court permit me, my lord.
Yes, Mr. Doctor. Have you gone through the order dated 2nd of December 2025?
That instruction I have not having lordship now. Can I have that notification lordship with my learned energy right now?
You have a copy?
So that I can take instruction on this. This notification covers the case of the petitioner. That matter is there. If this notification has been superseded, then there
litigation.
No, problem is that on the other day, Mr. U Sharma appeared.
That is our problem, Lordship.
And today you are appearing and you are saying that you are not aware of the judgment and
No,
order.
I have got the order, but no instruction received in respect of that order, Lordship. So I'll take care of this, Lordship, personally, Lordship, in the next year also.
Heard Mr. Bora, learned counsel for the petitioner, and Mr. Dotto, learned standing counsel for the respondent in secondary education department. Mr. Dotto submits that he has not received any instruction in respect of page number 74 of the petition. And if a copy of the same is furnished to him, then he will obtain necessary instruction on next date. Accordingly, taking note of the submission of Mr. Dotto, it is provided that recessal lays the matter in the first week of February. And in the meantime, Mr. Bora shall furnish a copy of the page number 74 to Mr. Dotto during the course of the day.
Right. Right.
Pending items 3 and 4.
My lord, that may be fixed.
3
Much,
and 4.
Mr. Bora, you keep this letter with you.
well,
Yes.
The Honorable Court was pleased to direct me to get the information
Yes.
regarding the status. Now, the person for whom I am appealing, he has already gone retired. And his, as per my information, that this entire principal of the school has been appointed by the government. The inspector of school is acting as teacher's principal. To this extent, probably I have got the information.
Yes.
It may be finalized and regular principal at least for this period may be appointed also.
Yes, Mr. Dotto. Who is appearing in this matter? You are appearing?
Yes.
Any objection in finalizing the list?
So see, that I have some objection because government has constituted the committee lordship in this. Whether from that committee, his case can be, his name can be taken care of and that's still or not lordship. Because both, one principal election was even constituted. So I am not getting marked lordship at this time now. Thereafter, one review copy has been filed and again that post. But I don't get the validity of this is up to good.
Whether any stay was granted earlier?
No,
There was no stay as such, but lordship, the select list was to be kept in seal cover lordship. That was the other pass. And now since it stayed at that stage itself lordship, the process says that it has to be forwarded to the state selection committee. The school selection committee has to forward it to the state selection committee and thereafter lordship, it would be considered by the government lordship. So that much needs to be done in this case now. The state selection committee, the panel that was formed, given lordship at page 55, that lordship will find.
When the list was prepared?
This was prepared on 18/12/2018 lordship. No, lordship, it was on 23/6/2019. 26/3/2019, this list was prepared and it stayed at this, that stage only.
No, usually one select list remain valid only for 1 year.
Yes, Lordship, but then
Unless there is any extension or whether it can be said today that the list is valid as on today.
that would come in had that list been forwarded to the state selection committee, Lordship. Since it has not been forwarded, Lordship, the list is Lordship still valid, Lordship. My submission will be that Lordship will kindly see the provision once, Lordship.
Any lordship that's listed very, each selection, now the selection will be governed by the reconstituted committee, not as per the ADIA committee, because.
Yes, I'm agreeable to that.
ADIA convention has been said that, and board director has to reconstitute the committee have to make selection and keep it in the chief of. That's it, before the convention, before this one, so. Wherein the petitioner has not got the highest mark. So what right has been exposed to that petitioner? This is my submission.
Lordship, to that, Lordship, my submission would be that although he did not secure the highest mark, Lordship, the school selection committee was required to prepare a panel of 3 incumbents, Lordship, and he is within that panel, Lordship, although he is not the highest mark getter, Lordship. So that Lordship will find at page 55, Lordship, that list. This is the list. His name is at serial number 4, and he is third, Lordship. The panel of 3, he is there, Lordship. Lordship, we kindly have a look at the provision, Lordship. It's if Lordship takes up this book, it's at page 377, Lordship. Rule 13. Has your Lordship got it?
Yes.
Rule 13, procedure of selection of principals. Number 1, before the end of each year, the member secretary of the school selection committee shall invite applications from the intending eligible candidates through an advertisement to be published at least in 2 widely circulated local newspapers. Number 2, on receipt of the applications from the eligible candidates, the school selection committee constituted under Rule 8(4), after scrutiny of the application, shall hold an interview and prepare a panel of names of 3 candidates on the basis of qualities such as leadership skills, administrative ability, integrity, and commanding personality. Number 3, the panel of names so prepared by the school selection committee shall be forwarded through the concerned inspector of schools to the state selection board constituted under Rule 16 for approval. Number 4, after receipt of the panel under sub-rule 3, the state selection board shall prepare a list equal to the number of vacant posts, taking into considerations such as leadership skills, administrative ability, integrity, and commanding personality. The panel of names so prepared and recommended by the state selection board shall be submitted to the government, which may, after causing such verification as may be deemed necessary, shall accord approval for appointment. Number 5, the select list so prepared and approved shall be in force for 1 year from the date of its approval by the government, provided if the school selection committee fails to prepare panel of names under sub-rule 2 within 6 months from the date of vacancy arises, the state selection board shall make the selection and prepare a panel of names following such procedure as laid down under Rule 13. So this is the provision, Lordship. Now, this list, Lordship, which is dated 23/6/2019, has to be forwarded to the state selection board, Lordship, under 13 sub-rule 3, and thereafter it has to be processed, and the state government is required to take a call upon that, Lordship.
But if there was no stay order, whether as on today it can be said that this page number 55 is valid?
This was kept under seal cover, Lordship.
Maybe seal cover will not extend the validity of the list.
This has to be taken up before the state government. After their approval only this will be valid, Lordship. Its validity would arise from then, Lordship.
No, that's all right. But now some of the candidates whose names were reflected in the said list have already retired from service.
Yes, Lordship.
Is it not necessary to exercise to initiate the exercise afresh?
Lordship, basically in their affidavit, the government has said that they do not have any objection with regard to this aspect, Lordship. They simply say that, Lordship, since the rules have been replaced by a new set of rules, it would be difficult for them to proceed with this, Lordship. Now, my submission with regard to that would be that, Lordship, in the new rules also, it's perimeterial, Lordship, with the older provisions, Lordship. So that does not affect, Lordship. They did not say anything with regard to the validity, Lordship. It has to be taken up with the state selection board, Lordship. Then only the question of validity after that would arise, Lordship, in my humble submission, Lordship.
Mr. Dutta, you obtain instruction of whether we can proceed with this list or the fresh exercise has to be initiated. Because 2 persons who were in the plane in the panel already retired. And virtually only one name of one person will go to the state selection board. Let it be in the first week of February. Heard Mr. MP Sharma, Learned Counsel for the petitioner. Mr. P.P. Dutta, Learned Standing Counsel for the respondent in Secondary Education Department. And Mr. Nandi, Learned Counsel for the respondent number 5. Though Bide order dated 15/12/2025. Mr. Nandi was directed to obtain instruction. Mr. Nandi today submits that the person concerned in whose favor he entered appearance before this court has already retired from service. And as such, the required information is not available with him. However, Learned Counsel for the petitioner, Mr. MP Sharma, submits that the annexure 1, page number 55 of the petition, may be finalized maybe finalize and give an effect to. Give an effect to, and in view of the provision of section
Rule 13, subclause 3.
Rule 13, subclause 3 of the Assam,
Some secondary education provincial, within bracket provincialization service rules 2003.
2003, has to be forwarded to the State Selection Board. State Selection Board.
State Selection Board. Lordship. It is board, Lordship.
Board. To the board. However, two of the persons, no, two of the candidates whose names also figured in the page number 55 of the petition. That is the panel prepared by the selection committee has already retired from service. In that view of the matter, Mr. Dr. Learned Standing Counsel for the respondent in Secondary Education Department is directed to obtain necessary instruction as to whether a fresh exercise has to be initiated or we can proceed with the list already prepared. This is a list the matter in the first week of February. Second case. 2847. Sir, your name please? K. Uddin. For the respondent number? 5. Respondent number 5. Okay. Both are same matter?
Lordship, that notification whereby the selection committee was allowed to proceed with that new selection, Lordship. That is a part of that case also, Lordship, because by that order itself, in another school, he was appointed as the principal, though both of us secured the same marks, Lordship. So that was put to challenge in the other writ petition.
No, my lord, not saying my lord. I got from my lord. He has contained this paper, my lord, who is not assigned my lord in his petition. I have anything in my affidavit, my lord.
Okay, on next that we will hear both the matter. Both the matter.
Lordship may keep it as part heard.
Okay. This is the list the matter is started.
Date. Like Lordship.
May please your lordship. Lordship, on the other day, they sort of sometime.
Sheet, director 8/1/2025. That was received and upon verifications certain further were required. Against which the secretary office had already communicated to the director Dikhi. Now they have to respond to that lordship. The lordship will find in second paragraph and third paragraph, lordship. Accordingly, the director BTC by letter number dated 8/1/2025 had furnished the fresh proposal for accommodation of teacher instead of tutor along with inquiry report, training certificate in respect of so and so and Dakshina last. However, upon examination of the said proposal, it was observed that the inquiry report submitted in respect of so and so does not contain the signature of BDO Baksar block. Further, the authentication of the training certificate has been done by the competent authority of the IGNOU. Accordingly, the department by letter dated so and so had requested the director BTC to resubmit the proposal with the necessary documents.
What lordship, resubmission, every time they are making resubmission, that resubmission of proposal, lordship. Now I am going to retire on July, lordship, 2026. And lordship, my case is somewhat different, lordship. At page 22, annexure 1, I was appointed as stipendary teacher. At page 22, second paragraph, lordship, if I may read, lordship. Page 22, annexure 1, I was appointed as stipendary teacher on 4/12/1999. Lordship got it. Page 21.
Okay.
Page 22, second paragraph, Lordship. The appointed will be appointed, it should be appointed. The appointed will be considered for regular scale of pay on successful completion of prescribed training as per existing norms and procedure of education department and subject to satisfactory police verification report. In case of failure to pass the training examination within the stipulated time of 3 chances, his service shall be terminated, for which no claim appeal will be entertained. Now your lordship may kindly come to page 24. This is the certificate issued on 9/4/2003. This is a certificate that Suneshwari Ramsiyari, it is the petitioner, so inhabitant of so-and-so, issued district some bearing rule number 46, issued the 1 year of service primary teachers training course held in the month of December in this basic training center Kokrajhar as regular private candidate and was placed in B grade by notification number so-and-so dated 12/3/2003. Now, lordship, page 25 is the service book opened. And page 28, if your lordship comes to page 28, regular scale of pay was granted to me. Page 28. Page 28 and 29, lordship. Page 29, she was allowed to draw the usual scale of pay with effect from 12/3/2003 as she has passed the BTC wide order dated so-and-so. Then page 30 is the GPF account was opened in her name. In the year 2003 itself. Up to page 33, 35.
So why she was not allowed to attend her duties?
Lordship,
Why she was not allowed to attend her duties?
that part, BTC would be able to.
Lordship, remember yesterday's matter, my
Mm.
lord, matter, is similar to that, my lord, only that they were praying for area salaries and he is here for accommodating him as tutor, my lord, from tutor to teacher, my lord. So these are the assistant teachers whose recruitment process were erroneous, my lord. They were initially appointed for non-sanctioned posts.
No, maybe, but his service was regularized here.
Yes.
Yes, after honorable court's order, their termination orders were withdrawn and thereafter they were accommodated, my lord.
Mm.
And that is why, my lord, because of
accommodated, but he was not allowed to join
Yes.
since 18/7/2022. What is the reason?
Joining letters were provided in the year 22 only after 2015 order for accommodation of these teachers, my lord. Thereafter, they were issued joining letter in the year 22, my lord. April 22, my lord. Similar, my lord, to all the assistant teachers, my lord. They were issued the joining letters, my lord. And thereafter, they have joined and they were continuing their service, my lord. In the meantime, they have some come for arrear salaries, my lord, and the instant petitioner is here for accommodating. him.
No, yesterday's matter and today's matter are different.
They were same appointment letters if you.
Maybe
By the deputy.
in the
No.
yesterday's matter, the petitioners were allowed to walk. They
Yeah,
are walking.
but because
And they have been releasing their salary, no, they have been getting their salary also. Here he was not allowed to join.
the reasons are not.
In the year 2009, she was terminated. In the year 2015, that termination order was withdrawn. In the year 22, she was appointed as tutor. Then she was again regularized by order dated 14/7/22. And she was allowed to join on 18/7/22. Later on, she was not allowed to join. Continue.
Thereafter,
Now, my prayer is this, that my prayer, Lordship, if your Lordship comes to my prayer, Lordship. Directing the respondent authorities to allow the petitioner to join her post as assistant teacher in Barhampur Balia LP School in terms of the order dated 14/7/2022, Annexation 7, and with retrospective effect, that is from the date of her reinstatement in service by the order dated 22/9/2015. This is my prayer, Lordship. Because she is to get otherwise she will not get pension under benefits, Lordship. She has to be considered from 22/9/2015 when her termination order dated 23 June 2009 was withdrawn. That Lordship will find at page 37. They are playing with the petitioner, Lordship, the authorities. Sometimes they are terminating, then withdrawing, then again appointed as tutor, then again regularized. This is absolutely mockery, Lordship.
What is your stand in the affidavit?
Lordship, the affidavit manner, we have stated that the termination was issued in pursuant to the Secretary BTC letter dated 13/9/2005 and 6/11/2008 on the ground of non-fulfillment of basic recruitment criteria, lack of advertisement, absence of approval by the state level empowered committee, no record of interview or score sheet, no selection list, and absence of the education board secondary education approval, my lord. Due to the fact their termination was done, my lord, and there are.
No, later on, she was accommodated as tutor.
Lordship,
Why she was not allowed to join then?
pursuant to the finance approval, my lord, taken a stand that every assistant teachers, there were sanctioned post of 109 posts were sanctioned, my lord, and accordingly, the eligible candidates were accommodated, my lord. Thereafter, after the order of the Honorable Court passed in Writ Bill 182 of 2015. Thereafter, BTC has taken that stand after going through a policy decision.
No, you are playing the same record. I am asking you why she has not been allowed to join.
That, my lord, is not clear in the affidavit, my lord. That is not. Is not clear.
They have nothing to say in this regard, Lordship. That's why they are silent in the affidavit.
Accommodating him as tutor has to come from the government. The approval has to come from the government. Thereafter, upon verification, he will be accommodated.
No, absolutely not. It is the BTC authority who has issued the orders. It's the
That
BTC
instruction I
authority.
don't have, my lord. Then why he was not allowed to join them?
You obtain instruction and come prepared.
Lordship,
You were appearing before the court without any preparation.
Lordship,
Huh?
this is what stand has been given in the affidavit, my lord, but this, and similar appointed teacher, those.
No, no.
The same.
You, in your affidavit, you have to deal with the statement and environment made by the petitioner in her petition.
Yes, my lord.
The basic part is not there. Why she has not been allowed to work even after appointment? That is not in your affidavit.
Lordship, that stand is not there.
Then,
We'll come up with.
then we have to accept the contention made by the petitioner as correct. We can dispose of the matter today.
Yes, Lordship.
Lordship may take it up after Bihu vacations, will come with proper instruction.
Heard Mr. Dhar, learned counsel for the petitioner. Mr. P. N. Sharma, learned standing counsel for the respondent in Elementary Education Department. And Ms. Bora, learned standing counsel for the BTC. 1 and 4. Mr. Solia is here. Respondent number? Respondent number 2.
I put 3, 5, 6, 7.
Ms. Bora submits that though the respondents in BTC has filed their affidavit in opposition, yet in the said affidavit, the statement made by the petitioner that she has not been allowed to join No, she has not been allowed to attend her duties, though she joined on 18/7/2022. Is not dealt with in the said affidavit in opposition filed by the respondent in BTC, and as such, she will obtain necessary instruction in this regard and apprise this court on next day. And press for listing the matter immediately after reopening of the vacation. Where allowed, press shall list the matter the first week of February.
20th of January, Lordship, 20th.
22nd, madam.
20?
22nd.
22nd.
Obliged, Lordship.
Lots of, in this case, lots of, this honorable court has passed repeated orders to allow my pay protection and lots of the scale of pay to the post of principal. That has not been done till late, and the petitioner is going to retire this month also.
Lord, the proposals were sent to the finance and finance stating that the release order, because earlier she was appointed. So the release order was made with the proposal, your lordship.
No, I was a subject teacher in PGT English also, not an assistant teacher.
PG teacher, your lordship. So that release order was not there, your lordship. So that is why the finances again sent, had asked for the release order to submit the release order.
I'm working in
Now,
the same school.
now it was submitted.
Lordship, lordship, see the second page of lordship, which has been communicated.
Which second page?
It's the second page, it was only yesterday that it was written to the Director of Secondary Education, your lordship.
Lordship, there is no question of release order because I'm working in the same school. I was working as a PGT English. Now, Lordship, I have been promoted in as a principal in the same school. Where is the question of release order, Lordship? Lordship, page 93 is my appointment order. May I kindly see at page 93, Lordship, of my writ petition.
No, you may be in the same school, but is it not necessary to release you from the earlier
Yes,
assignment?
yes, your lordship. Because in fact, indeed, with the documents I had gone through, your lordship, the documents that were submitted to the government, your lordship, there is an application by the petitioner to release her from the post of subject teacher as she has been appointed as the principal of the same school. So there has to be a release order, your lordship. So she has written an application to the principal in charge. However, it seems that principal herself the principal in charge, your lordship. So there has to be an order. And I had a talk with the inspector of schools, so lordship, and it seems that there is no release order. There is only this application, your lordship.
So now who has to forward the release order?
Lordship, as far as I know, your lordship, the release order is given by the principal of this. I was told herself the in charge principal. So now maybe your lordship who will give the release order. Take instruction to your lordship on that. I have to copy this. Oh, there's one here.
Yes.
Since the petitioner is going to retire this month, Lordship may kindly give expedite them, Lordship, because for last I was appointed in Lordship 11
That's
May
all right.
2020.
You furnish the release order.
Yes, your lordship.
Lordship may give a direction. Because I was myself, she was working as an incharge principal. Then she was promoted as a regular principal in terms of the selection process. Now, who will give her the release order? Someone, Lordship.
To be in the post of the principal, your lordship, there has to be a release order that has to be submitted. So she must have submitted some order, your lordship, otherwise that is the formality, your lordship.
And Lordship, as per earlier instruction, Lordship, all the documents, Lordship, that has been made, Lordship.
That has been given, your lordship.
All the documents have been already been submitted.
It has been submitted. Now we see that there is only an application, there is no release order. If the petitioner can furnish that release order.
Release order open দিব লাগে। Department.
Release order to, principal will be it.
কাক দিব? আমি কাক দিব?
Upon
Inspector.
very respectful.
Heard Mr. S.K. Das, learned counsel for the petitioner, and Ms. Mosare, learned standing counsel for the respondent in secondary education department. Mr. Soliha, you are for respondent number?
Finance.
Respondent number 3.
Respondent number 3. During the course of deliberation, Ms. Mosare has produced one letter dated 8/1/2026, written by the Deputy Secretary to the Govt of Assam Department of School Education, addressed to the Director of Secondary Education Assam. And submits that The Deputy Secretary to the Gupta Assam Department of School Education has directed the Director of Secondary Education Assam to resubmit the proposal along with the release order from the previous post for onward transmission, the onward submission of the same towards finance within bracket established dash a department. Establishment dash a department. A department. Accordingly, the petitioner no, you are to obtain the release order from the concerned
Lordship,
school.
school, your lordship.
And accordingly, it is provided that the Director Secondary Education Assam shall obtain the release order from the principal of the concerned school within a period of 1 week from today, and to submit the same to the finance department as soon as practicable. The petitioner is directed to cooperate with the Director of Secondary Education Assam. You forward a copy of the release order to
Lordship,
the
whether,
Director.
whether I can give my release order on myself, Lordship.
Yes, as inserts principal, you can.
Lordship. Same person. Lordship, I can submit today itself, Lordship.
Yes.
And Lordship may kindly give an observation that to expedite the entire thing before my retirement, because I'm retiring this month, Lordship.
Okay, Mr. Das also submits that the petitioner is going to retire on
This month, in January
on
2026.
31st of December, 31st of January. 31st of January is a holiday. 30th January of 2026. And as such, the respondent authorities are directed to complete the entire process before her retirement.
Obliged.
Obliged.
Number 41.
List the matter after, immediately after reopening of the petition.
Lordship, today we have some personal difficulties, so the matter may come on 3rd or 4th of February, Lordship.
3rd of?
3rd or 4th of February.
Okay. Mr. Soti, any objection?
In the month of January, ballot, February section of. Discussion that this ballot, his allegation, two allegations, one is in the regulation, another is petition of area. Answer is there. Answer is in the petition itself. He says how a principal can issue a certificate saying that he is not a student. What is this? Principal can issue. Seva has no role to issue any certificate. Seva only issue when he appear in the HSA examination then. Then the school authority, his allegation is answer is there in this petition, my lord. Nothing page.
Lordship, my senior will appear in this case. I haven't. My senior is like another.
Okay, let it be in the first week of February. Miss
T. Begum.
T. Begum, Learned Counsel, appearing on behalf of Mr. A. Rosset, Learned Conducting Counsel for the petitioner. With concern from the other side, press for listing the matter in the first week of February. They are allowed to list the matter in the first week of February.
Item number 13 for orders.
Wait, please. Make it a lot. I figure on the last instruction not the bank has forwarded the joint committee report with the recommendation of petitioner as a teacher. Now that proposal has been received by the secretary, and now the secretary has directed the director of elementary research department to send a formal, that was a joint committee report, now to send a formal proposal with the financial implications in terms of this High Court's order. So once that proposal is received from the director, further process will be taken care of.
No, you were to obtain the proposal because you were the container. Direction was
director.
issued to you.
I'm the container, director is the container here. The secretary, in fact, is not the container here. There was a direction of this honorable court to send the proposal of the petitioner to the secretary. So that proposal has been sent with the recommendation of the joint committee. So that content part is already complied with. Now your lordship has directed to further to bring it to the logical conclusion. That was the additional. In fact, the direction in the original petition was to direction to the director of elementary education department to submit the proposal. That was done. So that content part.
No. What was the prayer in the writ petition?
Writ petition.
To appoint
The
him.
prayer, lordship, the prayer was there.
Unless and until his appointment process is completed,
Lordship.
can it be said that you have discharged you have complied with the order of the court?
That was there
Huh?
in the prayer, but the order was.
No, my lord.
In fact, the secretary is not the container here.
My lord, there is a,
the sole container.
my lord, there is a clear direction for provincialization of service. My lord. Your lordship, kindly see the page number 19, my contempt petition.
There is recommendation. Lordship, there is a recommendation.
Kindly see, my lord.
He will be accommodated. The only thing is that.
Once such verification come to definite conclusion with regard to the provincialization of his services. My lord. Okay.
Lordship,
Secretary cannot escape, my lord.
I'm directed to requested to kindly furnish the form of the checklist 9. Statement showing financial implications and debt from which the provincialization is sought based on the established norms and Honorable High Court order to felicitate endorsement to the finance department. So this proposal has to be received from the director lordship now.
And moreover, if your lordship allow, I will make the parliament secretary. My lord. If your lordship allow.
Pardon?
If your lordship allow, I will make the party secretary as a contempt number.
Whether the secretary was a party in the original writ
Original,
petition?
yes, there is a party, my lord, in original repetition, in contempt petition, if your lordship allow.
Content was only for the director.
Heard Mr. Islam, learned counsel for the petitioner, and P.N. Sharma, learned standing counsel for the learned counsel for the contender. Mr. Sharma has produced one letter dated 8/1/2026 of the Deputy Secretary to the Government of Assam Department of School Education, addressed to the Director of Elementary Education, with a request to furnish a formal proposal with checklist 9 statements showing financial implication and date from which provincialization is sought based on established norms of HAC order to facilitate endorsement of the finance department.
Establishment norms and Honorable High Court order. It is in fact HSC was in sought.
So now when the director will forward the proposal?
Forward.
When?
Fix after perhaps 3 weeks or on the first week of February. The doctor may fix the matter. By the time I will also communicate the director, and they have already received that proposal they already received.
And on the basis of the said letter, Mr. Sharma submits that he may be granted 3 weeks time to submit the proposal along with checklist 9 statements showing financial implication and also the date from which provincialization is sought. Where allowed recessal is the matter on 1st of well,
On 6th February.
6th February. Mr. Islam Learned Counsel for the petitioner submits that he may be permitted to implead the secretary to the school education department as contender number 2 in this proceeding. Where allowed, Mr. Islam shall furnish amended cause title within 3 working days from today. The letter produced before the court today shall be marked as Annexure X and be tagged with the record. Mr. Islam shall also take step upon the newly impleaded contender number 2.
Hello, please.
Item 14.
My lord, in this matter, my lord, we'd like to withdraw our wakalatnama, my lord, so we'll take steps of notice upon the petitioner, my lord. So some time may be given, my lord.
Mr. S. Das, Learned Counsel for the petitioner, submits that he may be permitted to withdraw his wakalatnama, and also the rest may be directed to issue notice to the petitioner. Pair of Mr. Das is allowed. Rest shall issue notice to the petitioner within
2 weeks, my lord.
within a week from today. Rest shall list the matter after 2 weeks.
My lord, highly obliged.
Item 15.
Now, in this case, we have taken steps through paper publication against respondent number 1, 2, 3, 4, 9 and 11.
Hmm.
Now, the paper has been submitted, Your Honor.
When? You file an affidavit?
Yes, we have filed, Your Honor. It's on record, it is.
Third, Miss
And Rahman.
Learned Counsel for the petitioner and Mr.
For respondent number 6 and 7.
Respondent number 6 and 7. The Learned Counsel for the petitioner submits that notice upon the respondent number 1, 2, 3, 4, 9 and 11 have been served by paper publication. And an affidavit to that effect has also been filed enclosing the relevant paper with the record. No, relevant paper, newspaper with the affidavit. It appears that the notice was published in the newspaper Amarakhon on 16th of October 2025, and to that effect, one affidavit has also been filed. And as such, notice deemed to have been served upon respondent number 1, 2, 3, 4, 9, and 11. And in respect of other,
The service is completed in respect of others, Your Honor.
the Learned Counsel for the petitioner also submits that in respect of other respondents, service has already been completed. In that way of the matter, SSL is the matter for hearing. LCR has been called for.
Admi-
Whether LCR will be required or not.
LCF may be required, Your Honor. Because we have provided the certified copy of the order.
So certified copy will serve the purpose. Why record is necessary? SSL is the matter for hearing. Immediately after reopening of the vacation. Okay, next.
Abule.
Yes. During the pendency of this civil division petition, the Ranner Court of Civil Judge Junior Division, Rongya Kamrup, dismissed the title suit filed by the plaintiff respondents.
So
So,
this petition became infructuous.
yes, ma'am.
Okay. Heard, Mr.
M.
Learned counsel for the petitioner. The learned counsel for the petitioner submits that during pendency of this revision petition, the learned trial court has dismissed the title suit number 23 of 2014 by the order dated 28/10/2022. And in that view of the matter, this petition become infructuous, and accordingly, the same is thus closed. The letter on the order dated 28/10/2022 for certificate copy of the order dated so and so submitted before the court today by the learned counsel for the petitioner shall be marked as Annexure A and be tagged with the record. In view of the order passed in the CRP I number so and so, the I number 1367/2020 and I number 731 of 2021 also stands closed.
Yes.
May it please your lordship. Lordship, as per Lazima's order 26/8/25, services complete in respect of respondent number 1, lordship. (26/8/25), lordship.
Heard, Ms. Soike, learned counsel for the appellant. Order dated 26/8/2025 of the Laozima Court indicates that service upon respondent is completed. List the matter for hearing
Hearing, lordship.
immediately after reopening of the vacation.
Oblige, lordship.
Items 18 and 19. And 19.
None appears for the applicant on call. List the matter after vacation. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
Item 20.
Madam, now, after some days, I'm suffering. So came
Item number?
after vacation may come.
Item number
20.
20. Mr. Your name, please?
MK Majumdar.
MK?
Majumdar.
MK Majumdar, learned counsel for the applicant. You inform the other side?
Yes, yes.
With
I have
consent
informed.
from the other side, press for listing the matter after vacation. They are allowed, rest shall list the matter immediately after vacation.
21.
Lordship, the main suit in connection to this petition was dismissed. So we had filed a restorative petition, which is in under consideration. So until the restorative petition is decided, may this matter be kept in abeyance and like listed after 4 weeks?
On the prayer being made by Mr.
A. Mishra on behalf of PP Das.
A. Mishra, learned counsel appearing on behalf of Mr.
PP Das.
Learned counsel for the petitioner. The matter is then adjourned to be listed after 3 weeks.
Much obliged, Your Lordship.
Item 22.
Back, please, Your Lordship. My lord, neither etiquette nor answer report, my lord, has received back, my lord. And the office note was of November, my lord. I'll take fresh, my lord. Fresh step, my lord.
Heard, Mr. Sahu, learned counsel for the petitioner. Who filed the IA? You?
Yes, my lord. CRP is also this is for my lord substitutions.
IA, applicant in IA and petitioner in CRP, and Miss you
They were appearing on behalf of Mr. Air
are Dev, learned counsel appearing on behalf of Mr. Arsum, learned counsel for the respondent number. Respondent struck opposite party number 1. Mr. Sahu submits that though he has taken step upon respondent number 2A to 2C, neither edit card nor answer notice has returned till date, and Mr. Sahu submits that he may be permitted to take fresh step upon the aforementioned respondents. Where allowed, step be taken by speed post with AD and also by usual process within a week from today. Place the matter after 4 weeks.
Okay.
4 weeks.
23.
Lordship, service is complete, lower court record has come. The matter may be fixed for hearing.
Third Miss,
P. Goswami.
learned counsel for the appellant. The learned counsel submits that a service in this matter has already been completed and the LCR has also been received, and as such the matter is ready for hearing. Accordingly, it is provided that rest shall list the matter for hearing after vacation.
Nice.
24.
May it please, my lord. My lord, just a small submission. The petitioner herein is a Waqf estate. And as per the judgment passed by the Honorable Apex Court in 2022, matters relating to Waqf estate, even if be in relation to tenancy matters, are to be entertained by the Waqf Tribunal. And therefore, in a similar second appeal, my lord, this Honorable Court had directed that we have the liberty to approach the Waqf Tribunal. And with the Lordship's permission, I would like to pass the.
Now you want to withdraw this matter?
Yes, my lord, with liberty to approach the Waqf
Liberty to
Tribunal.
approach the tribunal.
Waqf Tribunal, my lord.
Okay. Third Mr.
N. Chaudhary.
N. Chaudhary, learned counsel for the petitioner, and Mr.
G. Diaz, my lord.
Learned counsel for the respondent.
4 and 5, my lord.
Respondent number 4 and 5. The learned counsel for the petitioner submits that
My lord, the Supreme Court's judgment should be
Supreme Court in
para
the case
45.
of Hemant, in the case of Rashid Wali Begum versus Farid Pinardi and others, reported in
2022 4 SSC, my lord.
2022 4 SSC 414.
Paragraph 45, my lord, is the relevant part.
Paragraph 45, observe that any question or dispute relating to property,
Waqf property, my lord.
Waqf property has to be filed before the Waqf Tribunal. And as such, and on the basis of the aforesaid decision of Honorable Supreme Court, Mr. Chaudhary submits that he may be permitted to withdraw this petition with a liberty to approach the tribunal.
My lord.
Any objection?
No, my lord, only there is one issue, my lord, that the respondents number 1 and 3 had died in the year 2021. So as of now, this matter stands debated, my lord. My lord, in that case, would the allowance of this application to be withdrawn would be proper, my lord. That is my only contention, my lord. Since the matter is already been abated, my lord, since the respondents number 1.
Abated, all right. Is it necessary to pass such order in this petition? Because he want to withdraw this petition.
I simply wanted to make the submission. I leave it up to your lordship.
My lord, otherwise the case will be filed afresh before the tribunal,
Yeah.
since the court has become quorum non-judice in respect of the matter after passing of the apex court judgment, which itself at length also discusses that even before passing of the judgment, it was to be construed that Waqf tribunal, which was formed as a special tribunal, had the jurisdiction to try cases in respect of Waqf property and not the civil court.
Okay, okay.
In that matter,
Mr.
you can raise up
Chaudhary,
the issue there.
Prayer of Mr. Chaudhary is then allowed. However, liberty will remain with the petitioner to approach the Waqf tribunal. Waqf tribunal.
Deeply obliged, my lord.
Item 25.
This is your. There was an IA, my lord. They were asked to file an objection, my lord.
Please, your lordship.
She submits that she want to withdraw the Ukalanama.
Yes, my lord.
Heard, Mr.
A Reka, my lord.
Learned counsel for the applicant. Miss
MDAS.
MS,
MDAS. M.
learned counsel for the opposite party. Submits that she may be permitted to withdraw her Ukalanama. In view of above, it is provided that recessal, the pair allowed recessal issue notice to the opposite party number, respondent opposite party number 1 and 2.
Yes.
1 and 2. List the matter after 4 weeks.
Interim order was there, my lord.
Interim order pass earlier shall continue.
26.
Here I file this objection, lordship. This matter was settled, but less amount has been paid, lordship. So I'll file the affidavit, lordship. He lakhs 50,000, 500.
This I is for what purpose?
They said that their amount has been settled for 11 lakhs. But it was and paid the earlier 3 lakhs 50,000 they have already paid. They said, but actually they have not paid. So we have got 11 lakhs, but the remaining amount is not deposited. Looks. Settlement was 14 lakhs, lordship. But they are saying settlement was 11 lakhs. So we'll file affidavit, lordship. So, time may kindly allowed to file affidavit.
Mr. A.R. Agora, learned counsel for the respondent. Who filed the IA?
Clement, lordship. Insurance company has filed the IA.
None appears for the applicant. On call, how about Mr. Agorola, learned counsel for the respondent claimant present? Mr. Agorola submits that he may be granted some time to file an affidavit. To file an affidavit. To the effect that an amount of rupees 3 lakhs.
3 lakhs. The amount is mentioned 3 lakhs 50,500.
3 lakhs 15,500 have not yet been deposited by the respondent, by the applicant, insurance company. Fair allowed, recessal is the matter after a week.
After lordship, after vacation.
After vacation, after. Okay.
May I please, Lord? It's a substitution petition, your lordship. Earlier, two petition, one delay continuation and setting aside of abatement, that has been allowed.
Yes, any objection?
No objection.
No objection. Heard Mr. Upadhyay, learned counsel for the petitioner, and Mr.
Abstain.
learned counsel for the
Open.
respondent, opposite party. This interlocutory application under Order 22, Rule 3, read Section 151 of the Code of Civil Procedure is referred by the applicant for substitution of the name of legal heirs and a representative of the deceased appellant, namely Kandarpa Kolita. Mr. Upadhyay submits that that appellant Kandarpa Kolita suffered demise on
23/10/2023.
23/10/2023 and in his place his legal heirs and representative are required to be pleaded as appellant in the RSN number 67 of 2016, and that another interlocutory application for condonation of delay and
setting aside of abatement.
setting aside of abatement have already been allowed by this court.
Yes.
By this court. And as such, Mr. Upadhyay has contended to allow this application. The learned counsel for the respondent opposite party submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this interlocutory application stands allowed. The legal heirs and representative of the deceased appellant, namely Kandarpa Kolita, be pleaded as appellant in RSN number 67 of 2016. In terms of above, this IA stands disposed of. And in view of the order being passed in this IA, Mr. Upadhyay, learned counsel for the appellant, shall file amended cost title of the RSN number 67 of 2016 within 1 week from today or after vacation?
After vacation.
Within 1 week after reopening of the vacation.
Lovely.
Item 28.
Next. Lordship, this is a cross objection. This may kindly be admitted, Lordship, and the inter case may kindly fixed for hearing after 4 weeks. After vacation. Yes. This cross objection may kindly be admitted and take to the main appeal.
But for the first time this matter is listed today.
Lordship, they filed this objection, Lordship, but
Actually, the cross objection is barred by limitation, my lord. The appeal was filed in 2011 and the cross objection is filed in the year 2025.
What is the period of limitation?
After admission of 30 days, my lord.
30 days. Where is the application?
Lordship, the appeal was dismissed. So after readmission, within 30 days, cross objection has been filed. Their appeal was dismissed, Lordship. Yes, Lordship. So it is within time, Lordship.
No, dismiss after hearing both the parties
No, Lordship.
for non-persecution.
Non-persecution. So simply cross objection may kindly be admitted and fixed for hearing the entire matter.
Fix the main method for hearing, and at the time of hearing, the lordship may consider the cross objection.
Because it is within time, Lordship. There is no bar. And cross objection also can be filed at any time, Lordship. After the date of
When
fixed
the
for hearing.
appeal was filed in the year 2011,
Yes, Lordship.
when it was dismissed,
It was dismissed this 2025, Lordship.
25.
Yes. And readmitted in 25, Lordship.
On 2018.
18, Lordship.
18.
8.
Then the period of 1 month will be counted from which date?
Readmission date, Lordship. Because the case was not heard, Lordship. After hearing, order
22, order 41 rule 22 lordship. And there are so many judgments also lordship. That it is within time lordship. After the date fixed for hearing lordship. It is only.
Okay, we will pass the order in the MFA.
MFA.
MFA. Heard Ms. S. Roy, Learned Counsel for the appellant, and Mr. Agarwala for the respondent number 1 and 2. 1 and 2.
Course of this may be take to the MFLOs.
Ms. Roy, Learned Counsel for the appellant, submits that the matter is ready for hearing. LCR has been received. Ready for hearing, and as such, she applies for listing the matter for hearing. Where allowed, justice shall list the matter after vacation.
After date may be fixed.
Along with the cross of this.
Also heard Mr. A.R. Agarwala, it separate order. A Learned Counsel for the cross objector and Ms. Roy for the opposite party. Ms. Roy submits that this cross objection is barred by the limitation, as the appeal was filed in the year 2011, and cross objection was filed
No, lordship, which are dismissed in
only
2025.
2025.
after readmission of the
However,
appeal.
Mr. Agora, Learned Counsel for the cross objector, submits that the appeal was earlier dismissed in the year 2020
2018.
or 2018, and the appeal was again readmitted on
2025. 2025. Yes.
12/2/2025.
Yes, lordship.
12/2/2025. And as such, the
Cross objection.
objection was filed within the period of 1 month from readmission of the matter,
Yes.
readmission of the appeal.
And
However,
now-
Mr. Roy submits that this cross objection may be heard together with the MFA number 23 of 2011. Accordingly, taking note of the submission of Learned Counsel for both the parties, it is provided that justice shall list this cross objection along with the MFA number 23 of 2021. The issue raised by Ms. Roy regarding maintainability of this cross objection on the ground of limitation will be considered at the time of hearing the MFA number 23 of 2020 or 2011.
Much of-
The document fixed and date will it hold matters.
19 February.
19.
Adjourned 29.
My lord, in fact, in this case, the petitioner's counsel expired. So we have got the brief only today and we are yet to file the wakalatnama. We will file the wakalatnama during the course in the day.
During the course of the day.
Course of the course.
Today.
They Friday, I 1733 of 2020, that was for withdrawal of the appeal with a liberty to file a fresh suit. The brief pendency of that I minor, the respondent number 1 expired. So I will inform the court and giving the details, that is the I of 453 of 2025.
453.
453. We have given the details of the respondent number 1.
No, who filed this or 453?
453 we filed because we are respondent number 2.
Okay.
Informing the court that respondent number 1 expired and giving the legal representative of the respondent number 1. Order 22 rule 10.
Heard Mr. Hawk, Learned Counsel for the applicant. Mr. Hawk submits that by filing this interlocutory application, the applicant has informed this court that during the pendency of RSA number 72 of 2012, respondent number 1 suffered demise. Mr. Your good name, please.
D.D. Chaudhary.
P.
D. Chaudhary.
P.D. Chaudhary, learned counsel, appearing for the opposite party, submits that the earlier setup on earlier counsel, he suffered demise.
Yes.
Suffered demise, and he has been newly engaged, and he will be filing his Ukalatnama during the course of the day. And he prays for listening the matter immediately after reopening of the vacation.
You have to file substitution petition because respondent number one expect.
Yes, we'll file.
Okay.
Number one, number five.
The learned counsel for the opposite party submits that he will file necessary application for substitution of the respondent number one. Respondent number one.
Mukleshwar. Mukleshwar Raman.
In that way of the matter, we can close this.
453 it may be closed.
453.
453 it may be closed.
Oh.
Because
Accordingly,
from the court.
Accordingly, this I stands I number 453 of 2025 stands closed.
1733. That I was filed for withdrawal of the second appeal, with a liberty to file a fresh suit. Will file objection also in this case.
Who filed this I?
This I was filed by the appellant.
Appellant.
And we filed objection. He wanted to withdraw the second appeal with a liberty to file a fresh suit in the trial court. Then we object.
You have filed objection.
We file. Without liberty, my lord, we have no problem, my lord. The appeal can, sorry, second appeal can be withdrawn.
Okay, let him obtain instruction.
Or
Mr. Swinson, learned counsel for the appellant, and Mr. Hawk for the respondent opposite party in I number 1733 of 2020. Mr. Hawk, learned counsel for the respondent, has pointed out that this I number 1733 of 2020 was filed by the appellant for allowing to withdraw this RSA number 72 of 2012 with a liberty to file a fresh suit before the learned trial court. But Mr. Hawk submits that the respondents have filed objection in this application. And as such, the matter may be listed for hearing.
Of the I.
Hearing of the I number 1733 of 2020. We are allowed to list the matter immediately after reopening of the vacation.
Item 30.
Please, Your Honor. Your Honor, Lordship, we have filed two substitution petition, Lordship, for substituting respondent number 1 and respondent number 2, Lordship. And while filing the substitution petition for respondent number 2, a delay of 2,790 days occurred, Lordship.
You have filed this I number 2899.
Yes.
Mr. Chaudhary, any objection?
No, first we have any objection.
No objection. Heard, Miss?
K. Bharat.
Okay.
Bharali.
Learned counsel for the applicant and Mr. Chaudhary for the opposite party.
Number 1, but actually, we'll put the respondent number 1 actually.
Respondent number 1.
Lordship, the respondent number 1 may be substituted, Lordship, because there is no delay.
If it's the thing.
Yes, Lordship. There is no delay in filing the substitution petition related to respondent number 1, Lordship.
This interlocutory application under Section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 2,790 days in filing the application under Order 22, Rule 2 of the Code of Civil Procedure. The learned counsel for the applicant submits that in respect of substitution of the legal heirs of respondent number one, there is no delay.
Yes.
But the delay of 2,790 days is in respect of
Correct. So-
respondent number two only. Substitution of legal heirs of respondent number two only. Mr. Chaudhary, learned counsel for the opposite party, submits that he has no objection in the event of allowing this application. Why there was delay?
Lordship, the counsel for the respondent number 2 informed us about the death of the respondent number 2 on February 2025, Lordship.
February 2000?
25. And thereafter we have.
Learned
it in subsidy-
Counsel for the applicant submits that the learned counsel for the respondent number 2 informed her regarding the demise of respondent number 2 only in the month of February 2025. And as such, there is delay of 2,790 days in preparing the present application, and the same is not deliberate. But same is not deliberate, but circumstantial, and the same has been explained in paragraph number 5, 6, 7, and 8. And therefore, she has contended to condone the delay of 2,790 days in preparing the substitution petition.
Actually, it was not informed by counsel for respondent number 2. It was the applicant who informed the counsel for the applicant.
Yes, yes, Lord.
Lordship, kindly tell us paragraph 5.
5, Lordship.
No, not in time.
Yes.
But they came to know through
True, and the
through the
applicant.
applicant only.
Yes.
Actually, they didn't have the knowledge.
Knowledge, yes.
When the applicant came to text of the case, they
Submission of
Counsel.
opposite party. Accordingly, taking note of the submission of learned counsel for both the parties, delay of 2,790 days in preparing the application under Order 22, Rule 2 of the Code of Civil Procedures stands allowed. In terms of this IA stands disposed of. In view of the order passed in the IA number so and so, the appellant in RSA number 278 of 2018
298.
298 Lordship.
298, 2000.
Yes, 298 of 2018 shall file amended cost title of the RSA immediately after reopening of the vacation. And the other is
Lordship, for setting aside abatement.
to beleg order of a burden. Why there are two substitution petition?
One for respondent number 1, substituting the legal heirs of respondent number 1, Lordship, and one for substituting the legal heirs of respondent number 2.
Okay.
That's when
The-
the respondent number 1 is
Separate.
separate.
Okay. Okay.
Much obliged, Lordship. May it please your Lordship. Lordship, during the pendency of this second appeal, the appellant number 1 expired. Therefore, we have come up with the 3 applications for substitution, condemnation, and abatement. We have even served a copy to the respondent side.
Hardness,
V. Rai.
learned counsel for the applicant. This interlocutor application under Section 5 of the Limitation Act 1963 is referred for condonation of delay of 1134 days in preferring delay for setting aside the abatement against the this is appellant number 1, within bracket Rajan Goswami. Why there is delay?
Lordship, the
No,
applicant.
the other side is absent here.
Lordship,
Respondent,
yeah, they're absent. We have even served a copy. They have received the copy of the same.
let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post. No, by
Lordship, the respondents are already appearing and we have served a copy to the council of the respondents.
but today no one appearing.
Today, no one appeared. Maybe next date they
You
might
take a
appear.
step. Let notice go at this. List the matter after 4 weeks. Step by speed post and also by usual process.
Publish.
Lordship, they have not come.
You are for the respondent.
Respondent, actually, I have no objections. Applicant number one died. Since others are already on record, so deletion of the name of the applicant number 1 they sought for. That can be allowed. That may be allowed.
But they are absent.
Well, let it come after.
Vacation.
Okay.
None appears for the applicant on call. However, Mr. Bhagavati, learned counsel for the opposite party present. It is to be noted here that this application is filed under Order 22, Rule 2 of the Code of Civil Procedure. Read with Section 151 for intimation, strike out of the name of. This is appellant number 1. That is, let Deepika Borua. This application is filed by you.
No,
They.
they.
Okay. Since the applicant has not turned up on a repeated call or is this the matter immediately after reopening of the vacation.
For hearing, item 54. I am hearing for respondent.
Respondent, none appears for the appellant on call. However, Mr.
S. J. Kolita.
S. J. Kolita, learned counsel for the respondent present. List the matter after vacation. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Item 35.
Yeah, I mean, the respondent. Lordship, maybe listed after vacation.
Vacation. On previous date also the appellant remain absent. None appears for the appellant on call. However, Ms. Musahari and also Mr. Goswami, learned counsel for the respondent number.
We are for the Oriental Lordship.
I'm for new. Respondent number 9.
Respondent number 9, you for respondent number?
The other is in the other case, I have the 9. In the
Only one matter is listed today, that is 115.
One doesn't dispose of, there are two methods, one has to dispose of.
Ms. Musahari for respondent number 3 and Goswami for respondent number 2. Respondent number 2 present. List the matter after vacation, immediately after vacation. In the event of subsequent non-representation of the appellant, appropriate order shall follow. Over.